All right, it's time for our favorite podcast, Cut to the Chase. And I'm bringing back Mike Burns because, again, it's like more information, just like all the time. And these are going to be a key update. So we had a last trial a couple weeks ago. It's going to bring him on then, but he was telling me, there's a couple things going on. So I said, all right, let's hold off. Let's try to get the whole package. What's going on? Victories, appeals, settlement, what's going on? So major victory, and there's a big appellate issue that kind of affects, or maybe affects, everything, and the judge wanted to talk to everybody. So this has all happened in the last couple of weeks. Fill us in.
Sure, it's great, Greg. Great to be back on Cut the Chase. I hope your mom's doing well. I know this is her favorite podcast as well. But we just came off a major win in our last case with Army soldier James Beals, Jay Beal. We won that case $77.5 million against 3M. It was the largest single case verdict that we've had. It was the last of the bellwether cases. 19 bellwether cases, 16 trials, 13 victories for the plaintiffs in those 16 trials. And it was just fantastic come off that big of a win that we had. Now, that's kind of sets up what's going on. We just had a meeting on Friday with Judge Casey Rogers here in Pensacola. She brought in 13, that was the magic number. She brought in 13 of the lawyers that are in leadership and that have the most number of cases, the top 15 law firms in the country as far as having cases. 334 different law firms represent clients in this mass tort, and the cases down. We were up at around 280, but now the real number is right at 240,000 cases that are still active in the MDL. And what Judge Rogers wants to do is, number one, she brought us together because she wanted to tell us what a great job we did, but at the same time, her goal is to get this case settled, and she wants to get this case settled by the end of the year. She wants to get as many cases resolved on this docket by the end of the year, and she's going to transfer all the cases from the administrative docket to the active docket and possibly remand these cases to the district courts around the country. And Greg, this will put a tremendous burden on the district courts, because you and I talked about this off the record, and it would give every district court about 2,500 cases added to their docket each year. If you put all these cases on the docket, that would take up a lot of resources in the district court. Currently, there are about 1,500 cases in the waive cases. She wants to get those cases worked up, and she's going to definitely put the cases that are in the Northern District of Florida. She's going to bring those into Pensacola, and she's going to try those cases just like she tried these bellwether cases. Another thing that you and I talked about, Greg, was the motion practice. Judge Rogers is going to handle all the motions in these cases, whether it's choice of law, whether it's Daubert, which deals with all the science in the cases. She is going to handle all that. That way there's consistency across the MDL, which is very important that you have those rulings. So if these cases do get remanded back to the district court, those district court judges can look at this like notebook or this cheat sheet, and they can say, okay, this has already been ruled on by Judge Rogers, and this is the way it's going to be. She's already done that with all the depositions, all the deposition cuts already been ruled on. There's not going to be any changes on those. So you can play those depositions when you get back to your district court, because you can't bring all these witnesses to trial in all these cases around the country. She also wanted to make the plaintiff's counsel aware of something. She knows that the face of the litigation is going to change over the next 6 months, just because of something that you mentioned, Greg, is there is an appeal. 3M appealed the initial case, the Estes case that came up first. The first case, it was a consolidated trial, Estes, Kiefer, and Hacker, which plaintiffs won that case, 7.1 million. But the defendants, 3M and the U.S. Chamber of Commerce, have piped in and filed a brief opposing that particular judgment and verdict that we got in that case. And they want to ask the 11th Circuit of Appeal, which is out of Atlanta, same one over Miami, up over here over the Northern District of Florida, and they've asked that court to reverse Judge Rogers' ruling and basically gut the case and say rule in favor of 3M. Now, we believe that that's unlikely. Judge Rogers believes that her rulings have been correct, but she says, they're not going to just rubber stamp what she did. They're going to take a look at it. And the one thing that's different, Greg, and you understand this as a good trial lawyer, is Judge Rogers had the summary judgment record. So she just had the evidence on the summary judgment. The 11th Circuit is going to have a trial record because these cases have been tried. So they're going to be looking at two different things. They're going to be looking at that summary judgment record and with a different ruling in that particular case. So that's why Judge Rogers and Judge Falk, who is one of the special masters over settlement, said, counsel, you know what? I want you to be reasonable and I want you to be flexible. We've got 3M to the table to discuss settlement in this case. I want you to be reasonable and I want you to be flexible when it comes to settlement so that we can hopefully get these cases resolved for these plaintiffs. Judge Rogers, as you know, served in the Army. She was enlisted, and she said, look, I served at some of these same bases that these soldiers served at. And I know what it means to get smoked because you didn't have your earplugs with you and you had to get out and do PT. So she goes, I've been in their shoes, and I think it's right for them to get fairly compensated. And I want you guys to be reasonable and I want you to be flexible so that we can help hopefully get this done. So that's where we are after that meeting with Judge Rogers on Friday afternoon and after the conclusion of the bellwether trials.
Okay, so I want to kind of break that down. That's a lot of stuff.
A lot of stuff, Greg.
A lot of stuff, and some of it I know, and some of it I don't know. All right, so just give me yes or no's, and we'll go down the list, and then we'll discuss, any clarification on any of these major issues. Okay, so there's over 300 different law firms that are handling 3M cases.
334 law firms are involved in the litigation. That's correct.
Okay, I'll take that as a yes. That's for the plaintiffs.
Correct.
The defendants, 3M, is there one law firm or are there multiple law firms?
They have multiple law firms, so handling their particular cases.
Okay, right now we're at about 240,000 cases that are on the administrative docket.
The administrative docket and the active docket combined. Correct.
The active docket means like they just filed the case like regular wherever they were filing it. So somebody from the military might have filed it in Chicago or Arkansas or California, wherever it was, but somehow or another magically now it's all in Pensacola in front of Judge Rogers.
Yes.
And you're telling me that there have been 19 soldiers in this bellwether process who've had their case, gone to court, and had a verdict one way or another. 13 victories,
Correct.
6 losses.
13 victories. Correct. Yes.
Every single victory, they've taken an appeal, 3M.
That's not correct. They've only taken appeal on 2 cases. They took appeal on the first case, which was Estes, Kiefer, and Hacker, and they took an appeal on Baker. So they have appealed 2 cases, a total of 4 plaintiffs. And the plaintiffs have appealed 1 case that was Denise Kelly, and we believe we have reversible error in that particular case.
So the 9 soldiers whose cases have not been appealed, have they been paid?
They haven't, nobody's been paid yet. All the verdicts have been stayed, pending the outcome of the appeals.
Okay, so is there one particular issue? Listen, I'm not an appellate attorney, but basically a lot of this boils down to 2 things: legal questions, factual questions. The factual questions typically depend on the actual case and the evidence and the particular person's injuries and their experience today. Were they subjected to all bombs everywhere? Were they, in some office in Spokane where they were, not subjected to it? The legal questions would be something that would apply across the board, typically.
You're exactly right. And so the main legal question is the government contractor defense. And basically what the U.S. Chamber of Commerce and 3M have asked the 11th Circuit to deal is they're basically asking the court to give this government contractor, 3M, immunity for for making these earplugs, because they're trying to say that the Army requested these earplugs and that they asked them to design them this particular way. So it's not our fault. It's the Army's fault. And they're trying to shift the blame from them 3M to the U.S. Army, government contractor defense. That's what their whole case is based on. Basically, that's what their whole appeal is based on. And then there's a second portion of the appeal that has to do with the Noise Control Act. And that requirement is by the EPA that every earplug package that is distributed, whether it's distributed to the Army or whether it's distributed to an individual, has to have an NRR rating on, noise reduction rating, on the label of the package. So you, as the consumer, knows what you're getting and what level of protection that you're getting. So those are the two main issues that are up on appeal in the 11th Circuit.
Okay, so I know you're not handling the appeals. You're like there at every freaking trial. You are the juice of my life, 3M. But so tell me, I mean, I know you got to like kind of, you know, like what are these like legitimate issues? Are there concerns? Or
well, they are legitimate issues, but Mike Saquette, who was one of the trial lawyers in these cases, he's tried at least 2 or 3 of the cases with us. Did a great job on the appeal. And then we also have Ashley Keller with Keller Linkner doing the appeal. Ash is a great lawyer and does a great job on appellate work. And so those 2 are handling the appeal. Judge Rogers thinks that the appeal will be complete by the end of the year. And that's why she says the face of the litigation will change within the next within the next 6 months. She says that on average, the 11th Circuit, once they get a case and briefing will close on this case by the end of this month, they like to resolve that within 90 days. So she believes in her heart that once it's closed, 3M will file their reply to our response to their initial brief. Once that happens, she thinks the 11th Circuit will set this for hearing. There'll be oral arguments, and that it will be resolved by the 11th Circuit by the end of this year. She also believes that it's possible for several things to happen. One, they may if they reverse her, they may gut it and throw out the plaintiff's victories. That's one. She goes, I don't believe so. She thinks I'm correct on her rulings, but anything's possible. She doesn't think they'll get rubber stamped. Number 2, she said it's possible that the defendants may ask for a rehearing after the Court of Appeal rules, and it's also possible that they may ask the Supreme Court to step in this place on certiorari, which, asks the question to send it up to the Supreme Court because it has not been decided. This issue has not been decided on a national basis. So that's why she said she is very concerned and she would like to get this resolved with the parties within the next month and get this case settled.
Okay. All right. So the last 2 things. One is when you're telling us she said this to you, she essentially set a conference with the lawyers. And I think you mentioned there were 13 different lawyers on leadership. So if you could briefly explain what the leadership is. So she invites, or she basically says, all right, you 13 on leadership, I'm going to tell you, I think that the appeal is not going to do anything. And but who knows, you need to settle the case. And here's what's going to happen. If the case continues, but it's not settled, I'm going to send this out to all the district courts across the United States, and they're all going to have 2,500 cases, and it's going to be a big free for all. Is that basically?
Basically, that's what she said. On average, that's what's going to happen. So in a nutshell, you're right on all those things. She took, like I said, 13 lawyers that are on leadership. Leaderships are the lawyers that she selected to handle these cases based upon applications that were made to be in leadership on this case. And then some of the law firms that have the top, represent the top 15 firms in the country with number of cases in this particular case. So she wanted to get the stakeholders to the table and express her concerns to them and say, the time is now.
Yeah.
for us to do it. And of course, you know, Brian Ailstock. Brian Ailstock is the lead counsel in this thing. He told the judge that if we can get 3M to the table, Your Honor, which Judge Falk says we have them at the table now, we'll get this done. So that is Brian's hope, is that we can get this done in the upcoming months.
Okay, so the long and short of it is maybe it settles, maybe it doesn't. Maybe the appellate court kills the whole thing, or maybe it guts the part of it, or maybe it doesn't do anything. And if nothing settles, then all these cases are going all back to the judges where the cases were originally filed. And so if you're one of these people, they're like, wow, 75 million bucks, I'd like to get my hands on that. Why can't I? No, it's not for you. Every one of these individual cases that have taken place so far, you know, if they win and they get past the appeal, they get the money. But you out there, one of these 240,000 people, you know, at settlement, forget about it. Go for it. Talk to your lawyer. Say, I want my trial. I want that 75 million myself. That's what I think. Okay, but I'm not, again, this is not advice. All right, now we're going to conclude on this note. Now, you know, we've had 7 or 8 shows. I've gotten to know you, you know, my family, I know you guys, you know, my health issues, my personality. So we're recording this the day after Tropical Storm Alex has passed through Miami. So I'm telling you, hey, I can't do this. We were supposed to do this the day before. I'm like, I can't. Come on, it's a tropical storm, whatever. And you're like, awesome. I'm getting my surfboard out and I'm going surfing. You're in Pensacola, so you're whatever, you know, 400 miles, you know, north of me or whatever. Like, how did explain? I don't know. I'm a Jewish guy from Miami. I hit a couple golf balls. Like, what's a guy like you surfing? Are you really surfing? Like, what happened?
Had some great waves yesterday. We had a little groundswell because the storm was down by you. So basically it pushed the waves up towards us, and we had a very pretty day with nothing but blue skies and sunshine. So we surfed in the morning. Then my wife and myself and a buddy and his wife, we went out on the boat and have a nice boat ride and everything.
Nice.
Went and got some good food over at the on the state line right close to the Floribama, which you've probably heard of that place. And then we made our way home just in time to watch a little baseball last night in the NCAA tournament.
Yeah, all right. Listen, you know, I mean, my Hurricanes, I think, are still in it. So
they're up right now, 1-0. No, they're down right now, 2-1 to Ole Miss in the 8th inning.
Well, you know, they for a while they were the top of the food chain, but now they're, you know, we just kind of hope that they are relevant. All right, listen, I'm going to let you go back to your surfboard. You know, I know that you were surfing. I mean, I actually heard people like, what's that old man doing taking my wave? And I'm like, that ain't no old man.
That's no old man. That's Mike Burns.
That ain't no old man. All right. God, my God. All right. All right. That's it for this episode of Cut to the Chase. I hope you understood it. You might have to listen to it a couple times. Maybe you'll ask us a question or whatever. This is not ending anytime soon. You're going to see this guy and me multiple more times. Okay. Thank you for coming on, Michael. And we'll talk soon. All right.
All right, Greg. Enjoy the rest of your Sunday.
Okay.